Swayam Prabha. Digital India. Educated India.
Hello viewers, welcome to the course on Law of Property. I am Dr. Jatin Kalon from Institute of Law, Kurukshetra University, Kurukshetra. Today we will talk about the jurisprudence of property. In the previous lecture we talked about what is property, its types, and discussed the technical terminologies related to the concept of law of property. In today's discourse we will try to achieve the conceptual understanding of the term property with respect to the scholarship of jurisprudence. Jurisprudence, as we all know, can be broadly stated as to be the science of law or the philosophy of law as well. Each and every idea that makes its way to become a law goes through the rigorous scrutiny of lawmakers, lawyers, judges, and general public. It is this journey that we are going to analyze today of that of property with the help of various observations made by eminent jurists from around the world who have contributed to our understanding of the concept known as property. The concept of property, possession, and ownership originated and developed with the growth in civilization, when humankind began to settle down to lead a more stable life. Today, property plays a vital role in every human's life. It is a key subject matter of one's rights and duties. The respect and protection attributed to the property rights of citizens of a country is a fundamental indicator of the country's prosperity and progress. It reflects economic freedom, opportunity, and development to an individual. As George Washington said, freedom and property rights are inseparable. You cannot have one without another. This is because property rights is a bundle of rights that affect different aspects of an individual's life. Neither liberty nor the right to life are secure without the right to acquire and hold property. Rights over property can be exercised via possession or ownership. The possession of a thing is a good title against the whole world except the real owner. Ownership is the bundle of rights allowing one to use, manage, and enjoy property, including the right to convey it to the other. To understand the nuances of this topic, it is important to understand thoroughly the legal concepts of property, possession, and ownership. Now, property is an important part of the economy. It is a vital institution in the economy of the society. In the past, this structure has been accepted and respected in a number of different ways. Fibrick says that the idea of property has never been, is not, and can never be of clear content. Still, people have tried to explain the idea of property. There are different ways to use the word property. According to some academics, it includes things that a person or a group of persons can own. Anderson and Parker say that property is goods and services that society gives one person or a group of people the exclusive right to own, use, and get rid of. This right of goods and services is expressed in the value system of the society. Property is something that is scarce and which one owns. It involves possession and ownership of things owned. It is controlled by the rules and habits of the community. Davis says that property is the rights and duties of one person or group against all other people and groups when it comes to some scarce things. Property, according to MacLever, is not money or things that you own. It is the right to control, abuse, use, or enjoy wealth or possession that may belong to one person or many people in the same social group, kinship, or clan. Hobhouse says that property is to be thought of in terms of the control of man over things. This is a control that is accepted by society and is more or less permanent and exclusive. Ginsburg says that the most important thing about the idea of property is that someone has the right to control things that belong to them and no one else can get in the way of that right as long as it stays within certain limits. Property is a general term, the term that governs people's access to and control of things like land, natural resources, the means of production, manufactured goods, and also texts, ideas, inventions, and other intellectual products. People care about how resources are used, so both agreements and conflicts about how to use them make them legally liable. When natural resources are in short supply and needed by all living things, they are especially dangerous. Some people have said that property relationships only make sense when there isn't enough of something. However, there are other reasons why people might disagree. For example, they might have different ideas about how to use a certain piece of land because of its past or symbolic value, even if land is not currently scarce. Intellectual property is an example of a property rule that doesn't directly respond to shortage. Also, intellectual property objects aren't in multitude like material objects are. One person using them doesn't stop many others from using them. Let us look at the different jurists who came up with the idea of property. Salmon says that the law of property is the law of proprietary rights, that is, right in rem. The law of proprietary rights in personam, on the other hand, is the law of obligations and is different from the law of property. In this sense, property includes a freehold or leased estate in land, a patent, or a copyright. It does not include debt, shares, or benefits that come from a contract. Salmon also says that the word property has been used in different ways. Let us have a look at them. The first one, he says, are legal rights. It includes all those rights which a person is entitled by a way of law. The things that a person legally owns are his legal rights. These are the rights which she can exercise over others. It includes both personal and property rights of a person. Second one, he says, are proprietary rights. It does not include personal rights. It only includes proprietary rights. It means that he owns land, goods, shares, or debts, but his right to live and his reputations are not included. Third one is, according to Salmon, is corporeal property. This only includes things that are real and can be seen, like land, goods, and so on. It doesn't count bills or shares as property. Now, for Hobbes and Blackstone, another eminent jurists, property that is protected by the law is important. On the other hand, Austin says that property is the most important thing that a person has. According to Austin, property includes whole of assets, whether personal or proprietary. Now, let us look at property from a jurisprudential point of view. Property rights are different from other types of rights and responsibilities in some important ways. the property owner can give or sell their property or give it as a gift. It can also be passed down from one family to the next. Now, Davis says that the idea of property always means that it can be given or sold, unless there are certain rules that say that it cannot be done. In this sense, a person's right in his wife or his skill are not property rights, for they are not transferable. There is also a difference between owning something and having it. People usually use the word property to refer to things that they own. In other words, property is anything that can give someone more rights to own it. The term property includes both living and non-living things. The property is made up of land, goods, shares and loans. In a wider sense, the term includes all those rights which a person has or can be exercised. For instances, right to life, personal liberty, reputation and all those rights which he can exercise against others. Hence, in its wider sense, it can be termed as all those things or material objects without which a person cannot live. Now, let's look at some important ideas that jurists have had about property. These ideas are both for and against the law of property. Here are some of the most important ideas. The first one we'll talk about is the natural law theory. Natural law theory is based on the idea that someone who has something is the owner of that thing. It provides that when an ownerless thing is being possessed by someone, then that person becomes the owner of that property. The reason is that the law recognized the property through its owner. This theory also gets recognized by law because the priority of the ownership of property is given to that person who is in the possession of that property. Several jurists agree with this concept. Grotius says that everything had no owner at first, and whoever filled it became its owner. Blackstone says that the natural law theory states that once someone starts using something, they become interested in it, whether it lasts a short or a long time. Some jurists, however, have also said this idea is problematic. Henry Maine says it is inaccurate to think that having the property does not give you the right to own it, whereas Bentham says that property is not created when someone occupies something that doesn't have an owner, but when the state makes it so. What he thinks is that property only exists when there are laws. Now, second theory is called the labor theory. This theory says that someone who worked hard to make something is the owner of that thing because it was made by him. However, this idea isn't accepted today because there are many ways to legally get someone else's property through a will or a contract. This idea about work is also known as the positive theory of property. Spencer agreed with this idea. He thinks that property is the result of someone's work and that someone who hasn't done any work to make the property cannot really own it. The third theory is the metaphysical theory, which was put forward by Immanuel Kant and Hegel. Both of them justified the theory, but this theory was not recognized as it is not concerned with reality. According to Kant, a thing rightfully belongs to someone when he is connected with it in such a manner that when someone else uses it without consent, it causes damage to the owner also. He says that in this idea there is a physical link between the owner and the thing being owned. Hegel says that a person's property is the objective mark of their identity. To put it another way, property is something that a person has the right to use however he wants. Next theory is called historical theory. This theory is about private property and how it has grown slowly but steadily over time. Bentham came up with this idea, and Henry Maine agreed with him, that the growth of property is in three distinct stages. In the first stage, people start to feel inclined to take things they naturally own and use them without following the law of the state. In the second stage, juristic possession is added. This means that the person has possession both in fact and in law. In the third stage, the legal owner of the property is taken into account. The law says that the owner of property has the only right to use and control that property. And the last one is the physiological theory. This theory provides that the property came into existence based on the tendency of a human being. Everyone desires to own things and to exercise control over them. Bentham agreed with this idea and said that property is a thought of mind. It is nothing but an expectation to own a property and make use of it to the fullest. Dean Pound agreed with Bentham and said that the idea of property comes from a person's desire to own and control something. Property rules determine who can use and manage land and other things that can be seen or touched. There are interesting ethical questions about the right to property because these rules are not agreed upon, both in terms of how they should be interpreted in general and in terms of how they should be used in particular. These days, most philosophical debates are about why property rights are important, as opposed to shared or collective property rights. One type of property is private property, which means that certain things like pieces of land are given to specific people to use and manage however they want without anyone else, even people who need the resources more or any detail controlled by society. Philosophers have often said that private property is important for the moral growth of each person or for making a society where people can thrive as free and responsible agents, even though these exceptions make the idea of private property seem a little problematic. So, there are three species of property arrangement: common property, collective property and private property. In a common property system, resources are managed by rules that allow anyone in the society to use them. In a town, let us say, everyone can use a piece of common land to do things like graze their cattle or gather food. Anyone can go to a park and have a lunch, play sports or just relax. Any limits on the use are only meant to make sure that everyone has equal access and that no one uses the shared resource in a way that stops others from using it. When people have collective property, the group as a whole decides how to use resources. These determinations are made on the basis of social interest through mechanisms of collective decision making. Anything from a leisurely debate among the elders of a tribe to the forming and implementing of a Soviet style 5-year plan. Private property is an alternative to both collective and common property. Property rules in a private property system are based on the idea that different resources are given to different people, or let us say families or businesses, to decide what to do with them. The person who has power over an object is the one who should decide what to do with it. It is not thought that she is acting as a servant or official of society when she uses this power. As she pleases, she can act on her own without telling anyone what she is doing, or she can even work with others to get things done. She could even give this decision making power to someone else. who would then have the same rights as she did. A person who owns a resource usually has the right to make her own decisions about it, even if those decisions affect other people. Getting the property through inheritance is one way to do it. So, in conclusion, property is what a person gets during his lifetime, whether he gets it himself or gets it from someone else. Property can be thought as both personal and private. Every individual is entitled to personal as well as proprietary rights. Several well-known jurists have written about the idea of property from a legal point of view. Some jurists have supported the concept of property while some are against it. In the field of law, the idea of property is very important. It also talks about other property-based ownership rights which are established by law. The idea of property is very important in law because it is the only thing that can be used to determine private rights like ownership, title, etc. Again, rights and duties are also closely related to property. Because of this, the law about property has grown into its own field of law within logic. It has been known for a long time that property rights are basic civil rights. Today, the basic legal right of property has grown to include the modern concept of intellectual property. It is also important to note that there were also changes to the right to property under the Indian Constitution. The final form in which the right to property was incorporated in the fundamental rights declared that all citizens shall have the right to acquire, hold and dispose of the property. But it has changed from a fundamental right to a constitutional right and recently being held as a human right. There were changes in both the political climate of the country and the area of constitutional law after the emergency. The Constitution 42nd Amendment Act 1975 made major changes to the Constitution. The main goal was to get rid of the things that were getting in the way of socio-economic improvements in the Constitution's growth. The Constitution was amended to make the ideals of socialism, secularism and the integrity of India more clear, to make the guiding principles more general and to bring about changes in society and the economy. At this point, the right to property became a legal right because of Article 31 Clause 1, which was added under Article 300A and says that no one shall be deprived of his property by the authority of law. So, this was all for today. We will discuss more about law of property in the forthcoming sessions. Thank you for watching the program.